Next question. Can we temporarily lay off staff while still claiming furlough to avoid holiday entitlement? Again, the short answer to this is no. Furlough is a mechanism to avoid layoff or other redundancy measures. So while as an organization, we can have certain members of our staff on furlough and others working or lay off others because we need to, we cannot lay off and furlough the same individual simultaneously. It is a scheme to avoid layoffs. It's a scheme to avoid redundancy. So for anyone furloughed, that is it. That is their workplace categorization. They cannot be on furlough and on layoff at the same time. But also, I think it's worth pointing out in this question, again, bearing in mind that underlying employment law principles haven't gone away, the accrual of statutory holiday entitlement is entirely unaffected during layoff. So during furlough, during layoff, statutory holiday entitlement continues to accrue. It remains at 5.6 weeks per year under the Working Time Directive, and it is paid at the rate of a week's pay for each week of leave. So I set out some of the principles there, but it's just bearing in mind, and this is why I said it outset, we cannot look at furlough with blinkers on. Underlying employment principles, underlying employment benefits, rights, timetables continue to apply, and it would be folly for an employer to ignore those or for an advisor to fail to remember that those are also critically important. Next question. Do umbrella companies only have to pay their employees minimum wage? So this can be fairly convoluted. Consider what do we mean by employees minimum wage? If that means national minimum wage and the living wage, bear in mind that those do not apply in furlough. That may be slightly surprising for us all, but there was specific guidance in this. Both of those schemes are designed to reflect a minimum rate of pay when working. If an employee is in furlough, they're clearly not working, then the national minimum wage is disapplied. There are slightly different rules for apprentices, so apprentices don't drop beneath a certain threshold, but national minimum wage can be disapplied for the purposes of furloughed workers only. So let's just think about some of the principles. An employer who is successfully using JRS will recover 80% of gross base pay, capped at 2.5k per eligible employee, plus employer national insurance contributions and employer auto-enrollment pensions contributions on the subsidised sum. All monies recouped under that scheme must be paid to the employee or assigned to the pension contributions, i.e. the employer pension contributions, auto-enrollment, will be recouped by the employer, but the employer does not pay those to the employee in payroll. The employer assigns those to the appropriate pension provider. Employers do not have to top up the difference between what normal monthly wages might have been and what the scheme pays out. This remains discretionary, but it is subject to the employee having consented to furlough. So these are the monies that we can recoup. Those are the principles that apply, but it still goes back now to the critical need for informed employee consent and express consent. So that's why I say and emphasize these payments, this approach is always subject to the employee having consented, and that requires informed consent. And to get informed consent, we have to have also made sure that we have issued clear communications to the employee as to the impact of furlough generally, and also in relation to what it will do to their rates of pay, their deductions, etc. And that goes right back to the other point we make about employee deductions and about how those will continue to be made from the subsidised sum unless and until the employee writes and confirms their instruction to the contrary. And fundamentally, let's also remember that even if a business was furloughing and paying anything less than their contractual rate of pay to an individual, that still represents a change to the terms and conditions of employment, and that still requires consultation and consent. Because if we don't consult, if we don't consent, and we don't discuss and deal with any queries the employees have, it will be a unilateral change to the terms and conditions. It will probably, depending on quantum, be considered a material change to the terms and conditions, which renders the employer exposed to a number of claims, potential constructive unfair dismissal, although I don't know who would do that in the current climate, but certainly latent claims of unfair dismissal, as well as unlawful deductions from wages, etc. So I know it's a stark reminder that employment law and the contentious side of that remains, but certainly we're already seeing as advisors a number of employers who are receiving solicitors' letters from individuals who believe that their eligibility for furlough should have been different, or that the rates of pay applied should have been different. So unfortunately, you know, there is going to be a range of litigation coming out of this. So it is critically important now that we do the bare minimum in terms of compliance with government guidance, which is, as I say, making sure that we communicate clearly and we get express consent. Next question. Are employees with temporary national insurance numbers, assembly payroll, given by the employee eligible for the furlough scheme? So I wasn't entirely clear in relation to the question, but nevertheless, the answer to this is basic principles. Go right back to the government guidance, and for eligibility criteria for this scheme, employees or casual workers and certain Lim 2 workers like consultants, for them to be eligible at all, they must have been on the applying employer's PAYE system by the 19th of March, and their details must have been updated by the employer making an RTI submission by that date. Those are the two key principles. And if those aren't satisfied, then actually everything else is academic. However, if we can satisfy those two criteria, then I would say all applications should go ahead. And if there's any doubt whatsoever, then affected employees should be made aware that eligibility is conditional upon HMRC approval. So that is a piece of comms that we would send to the employee affected. And the corollary of that is that if there's any doubt whatsoever, then our payroll and or our accountant should be in contact with HMRC and ask this specific question. There will be guidance out there for this category of worker and considered in this question. But fundamentally, two key principles: PAYE by the 19th of March, and the employer makes an RTI submission by that date. What we're also seeing is that the employee, new starters in particular, may well have been in PAYE, but the employer has been slow to make an RTI submission. That's a concern, because that is where the employer has probably left themselves at risk, because they have failed to clear one of the first hurdles for JRS, and that is a hurdle which is not in the bailiwick of the new starter employee, and that may be where we have a slight exposure. So again, just check those two key hurdles to application criteria, and that's probably as much as we need to say on that one. Next, if an employee is off sick, again with a recurring condition, can we make them redundant as the business is taking a downturn? So look, very common question, but again, I think it's pretty clear. We should separate out the two principles. One, sickness absence generally, which is the underlying query here, should be addressed through its own absence management plan, and that takes its own pathway, whether it is persistent absenteeism or whether it is one period of long-term absenteeism. But we have our underlying employment principles and protocols. We need to apply those. Redundancy is an entirely distinct process. We cannot use redundancy to punish employees because of persistent absenteeism, for example, or because of we use redundancy when instead we should really be running a capability management plan and a disciplinary process, etc. Now, that is not to say that absence cannot be part of a redundancy selection matrix. Neither is it to say that disciplinary matters cannot be part of the redundancy selection matrix. But we start with the answer or the question here: if an employee is off sick, can we do something? Well, if an employee is off sick with a recurring condition, what you start with is an absence management and a sickness absence piece, occupational health, etc., an understanding as to whether or not the individual might be disabled within the meaning of the Act, what we need to do to bring them back to work. Equally, redundancy is entirely separate. If the business feels that it needs to run a redundancy process, then run a redundancy process. And if that happens to sweep up this employee or this category of employee because you have in your selection criteria something which deals with absence, generally that's done under the Bradford Index, where absences are weighted and scored, and that is legitimate as long as it's not the sole criterion. Then fine, you can still do it, but just be very, very wary of classifying someone as redundant when actually you should be running a different process under employment law, because that's classically something that will come back to bite any employer doing that, and there'll be claims of discrimination as well. Next, so 2 quick ones. When should I start talking to furloughed employees about possibly reducing days or hours or making them redundant after lockdown is lifted? So my answer to that is now. Whether or not the JRS scheme goes beyond the 30th of June in any way, shape or form, if we know that the business is in a critical state and will need remedial action taken, which may be redundancies, it may be restructuring contracts, it may be part-time, lesser hours, etc., then you should start that consultation as early as possible. For 2 reasons. One, the business will fail completely if we leave it to the end of JRS because we're holding our breath. And secondly, because of consultation rights. If we're doing this within a workplace and more than 20 employees are affected, then we have potentially a collective consultation situation, and that requires 90 days consultation in Northern Ireland, 40 to 45 in GB. So don't be confused by a Google search on that. And if we're going to make changes, then we should start that consultation early. So at the very least, as an employer, we can run our consultation in tandem with the last days, weeks, or month of the JRS scheme. Then, can we claim furlough for only some of their hours, i.e. 35 hours worked but only need to furlough 15? No, you were either furloughed or were not. You can't part-time furlough people. That's one of the less flexible elements to the furlough scheme. So it's again a relatively straightforward answer to that. So we'll crack on. Let's have another one. So the next question is, an employee is a single mother who can't work due to having no childcare. Can she be furloughed? So again, the key word here is can. You've heard what I've already said about the principles of the JRS scheme, so I won't go over that again. But my answer to this is that the employer can put in an application for furlough here, but it is not obliged to. So again, JRS was initially for employees otherwise facing layoff or redundancy. By the sound of it, this employee is not. But given that the JRS has been extended for certain vulnerable categories of employees, we've talked about shielded and shielding, and the extremely vulnerable, then guidance has also indicated that it can be extended in circumstances where we consider the situation of the individual. And this is a classic, a single mother who can't work due to having no childcare. Moreover, we have seen situations of single mothers with very young children who find it extremely difficult even to get a shop in because they're so heavily reliant on relations, generally grandparents, where they cannot, because they themselves are vulnerable and social distancing, it puts this individual in a completely invidious situation. So yes, the short answer here is you can make an application for furlough. It's not classically what furlough was designed for, but enough government guidance exists to suggest that it would be an appropriate application. And certainly the LRA, the Equality Commission, I was reading some of the Equality Commission guidance this week, and they would be saying that when an employer selects for furlough, consideration should be given to this category of worker. But again, even they caveat their advice by saying, for an employer who is considering furloughing anyway, i.e. it's a business which is furloughing a number of employees, when you make that decision, then you can apply discretion as to some of the people who you select. So the Equality Commission is more talking about selection once as a business you've decided to furlough, not for a business which is not otherwise furloughing, can you put someone in? So it remains a slight grey area, but I think you could probably veer on the side of being humane in this and permit the application for 1 or 2 individuals within the organisation and see how it goes. I can't imagine HMRC will come back so aggressively in that. Next question. Can I make my employees take annual leave while being furloughed? Well, yes, but we can't answer this without seeing the individual contract of employment issued by the employer, signed by the employee, as well as custom and practice within the workplace as to how you apply contracts and annual leave, etc. So let's assume that there is a contract of employment issued. Most contracts actually permit and require the employer to control annual leave. Employees need to ask permission for leave requests. It's generally granted, but the principle remains that the employer can reject it if they need to. So the same principle applies here. Can you make employees take annual leave? Well, yes, you can, and a lot of employers are. How they communicate that is fairly careful. So we have 2 points. One, even if we do require employees to take annual leave, their leave should not be fully exhausted during the furlough period. And it's certainly not all of their annual leave for calendar year 2020. It's only that annual leave which is accrued to date, i.e. any employee should still be able to have the facility to take some annual leave in the remainder of the year following the return to work. And that's legitimate, entirely logical. The pressure point in this is, can I make my employees take annual leave? So the way it should really be approached is the employer is requesting that employees take, for example, 50% of their annual leave or 70% of their accrued annual leave whilst on furlough. The upside to that is that when they take their annual leave, they get 100% normal pay as opposed to the subsidized rate of pay. So there is a financial incentive. The downside is that employees may reject absolutely. So if they reject absolutely, the fear for the employer is that we have built up a huge bank of annual leave, which is accrued, and a lot of employees will want to take it as soon as we're out of furlough. Well, again, this goes back to the first principle. You still control annual leave. So if the employer refuses to take it, the employee then will come and ask for annual leave at a particular point in time. You're perfectly within your contractual rights to deny that. And say that it's not appropriate time for the business, so your request is refused. The government has already anticipated that, and they have changed additional legislation for furloughing to allow employees to carry over accrued annual leave from this pandemic period for up to 2 years. So they're not necessarily going to lose their annual leave, which would be a breach of the working time regs and a breach of common law practices. But we're not necessarily saying they can take it when they want, because the business needs come first, particularly because we'll probably be in a really difficult financial climate whenever lockdown is lifted to try and get our businesses and all other businesses back up and running. So short answer to this, yes, you can control leave, communicate what you want, be crystal clear what you're going to do, and just be really, really careful that whenever we apply one rule for one, we apply it objectively for all. Otherwise, while you can still control leave, you'll be facing allegations that you have preferred a particular clique of workers or an individual over another. And why is that? Classically in Northern Ireland, lawyers like to throw in, oh, it must be because I am black, white, Protestant, Catholic, male, female, which I hate as a lawyer to see, but nevertheless it happens. So bear that in mind. That's the kind of thing you're dealing with in due course whenever you've got a gunfighter of a solicitor that doesn't really care about normal practice and just wants to try and run a case. So those are the underlying legal principles you still need to remember in relation to that query. So the final question in relation to the slide deck, and I know we're some live questions which Johnny will pick up and run with in a moment, but the final question I'm going to deal with here is, does the one letter of consent cover the whole period of furlough as per government extensions, or do you need an updated permission as per extension? So I have covered this as we talked through the other questions. So one letter of consent absolutely can cover the whole period of furlough, but it depends what you have said in your letter of consent, and it depends whether or not you have left it open-ended, i.e. you're furloughed now until such time as, or if you have left it closed, you are furloughed now for a 3-week period to the 1st of May, for example, or whatever it was. So go back and check out your letter of consent. Make sure that it covers the entirety of the furlough period or as much of the furlough period as the business needs. If it doesn't, then go back and get a better letter of consent now, or clarify what you meant in your letter of consent, but certainly get some communication issued on that. Because as I've said here, and it's an important point, HMRC have confirmed over and over again that all employers who are availing of the JRS scheme for one employee, for 1,000, for 1 3-week period, or for 3 months, it doesn't matter. Any employer availing of this must keep written records of all comms issued to employees in relation to this for 5 years. And they have also reinforced again the need for express written consent. My final point on that is note the 3-week rule. The three-week rule is not about going needing consent every 3 weeks. It is about a minimum. Each period of furlough must be for a minimum of 3 consecutive weeks. If it's less than that, the employer loses the benefit. But given where we are in furlough now, we're a number of weeks into it, we're generally beyond the 3-week principle. So this is more an issue now for employers who are going into it for the first time, or employers who are beginning to come out of furlough and are actually needing to go back in for very short periods of time, or who are rotating existing workforces. So let's get our consent right.